Good evening. How are you? I'm John Flannery, and this is another sit and talk, in part because of the heat and the rain outside. So I'm glad to be with you. And the thing I want to talk about is American hypocrisy about women. This nation talks about women and children with whispered respect and care. But that's it. When it comes down to making decisions and policies that respect women, we come up short, especially these days, especially since the overthrow, wrongly, of a precedent, Roe against Wade, which talked about the right of a woman to have dominion over her body. So a woman should be able to say she doesn't want to have a child because she can't care for it, or her health won't permit it, or she's been raped. Or there are a whole variety of other concerns, none of these that justify a woman saying, this is something that is unwanted or can't work, or we thought it would and it won't now. Men have no business interrupting this discussion. And I mean it, all men, elected men, citizens. If there's anything that a man in America should be doing, should be respecting the right of a woman to have dominion over herself, just as a man would expect it for himself. Now, this all comes to a head because of funding, Medicaid funding for abortions in America. A United States District Judge, Indira Talwani, said Congress's legislation was wrong, blocking Medicaid to Planned Parenthood for abortion services. She called it a legislative punishment, and those are words that mean something in this context, and they mean something in connection with the Washington Post editorial, which was dead wrong on this thing, attacking and criticizing the judge and saying she was wrong in a variety of ways. And that's what has prompted me to want to discuss this. Of the 10 issues we could talk about, which are the demons and failures of the Trump regime as we go day to day. She called what happened with Planned Parenthood a legislative punishment, a violation of First Amendment rights as a reprisal for what they have to say about these subjects. The Post editorial board said, this is judicial overreach. Oh, that's very interesting. Now, I assume there are women on that board, and I don't know how they could sit on that board and say that about that decision. Is it okay if you're wealthy and can have abortion, but a poor person can't have an abortion? We won't help them get an abortion. And what kind of equity is that in a system that pretends to have due process, to be fundamentally fair, to talk about judicial equality between parties? Now, the austere editorial board of the Washington Post said, we all know the budget process is inherently political. Now, what kind of a statement is that? In other words, Congress can make a political decision about how it spends money on things that certainly fit under the general welfare and are historical caring for people. Of course, this is also a healthcare decision, and America should be ashamed. I mean, every other country around the world is trying to provide healthcare, and we don't. And, this is just impossible. So the board said these tax and spending bills always help some groups and hurt others. So I want you to, just put a bookmark there for that's what they say. Because they know less law than a 1L, that is a first-year law student. The board said the judge is blocking an act of Congress. Whoa, and they're saying that judges can't say anything about acts of Congress? Anybody on the board ever hear of Marbury v. Madison? That was a decision in 1803. It established the principle of judicial review. That is, the power to declare a law passed by Congress was unconstitutional or not. That is the basis of the judge's decision in this case. And the board knows so little law that they don't even know the framework in which she is choosing to attack this withholding of funds, of Medicaid funds, for Planned Parenthood. So, and the answer is Was there a constitutional violation? I'll get into that in a minute. Now, doesn't this board owe its own readership, especially the women, to get the law and the facts right? And let's talk a little bit about that. But before looking into Judge Talwani's 58-page decision, and you wonder if they read the decision, because it's not evident from today's editorial. In our Constitution, and these are the constitutional provisions that the judge concerned herself with, no bill of attainder or ex post facto law shall be passed. Shall be passed. Congress can't pass such a provision. And shall means it's mandatory. It didn't say may, it said shall be passed. None shall be passed. Now, dust off your copy of the Constitution. And it may be at hand because we've had a lot of reason to refer to it since Trump has decided to break down our system of government, once a fairly respected constitution of democracy and republic. Dust off your Constitution, look at Article 1, Section 9, Clause 3. That's where it says no bill of attainder or ex post facto law shall be passed. Okay, now you may or may not be unfamiliar with that, but let's talk about it a little bit so we understand what those words mean, because they go back in history a long way. And it's kind of interesting because in 1833, Justice Story made a preliminary review of the Constitution. So for 1833. And it's interesting, and I'll attach the picture with this. It was for colleges and high school. So when the editorial board doesn't get this point, they didn't take Justice Torrey off their bookshelves and take a look at it. Now, he's on my bookshelf, and it's just because, well, I think the law is a good place to start when you have a dispute or you're wondering how to organize an entire government. And apparently the Washington Post doesn't see it that way. So a bill of attainder is legislation, an act of Congress that imposes punishment on a specific person or group of people without a judicial trial. Why a judicial trial? Due process. If somebody hasn't proven it in a judicial trial, and legislation can't because there's a separation of powers between the legislative and the judicial branch and the executive branch. Listen carefully, you people over at the Washington Post. These are very elemental things that you should know about. And to issue an editorial about something as important to this that, I don't know, more than half of our population, I believe that, it's not 50-50. I believe that 51, 52, 53% of our population is that. And what proportion of that population is poor? And what proportion of those poor people need Medicaid to decide whether or not to have an unwanted child or not, or one that hurts them or not? How about that? Judge Talwani explained how the punishment was contrived in this case. In her decision, she noted that this bill, the spending bill, was written as it was as a reprisal for First Amendment exertions by Planned Parenthood, denying them equal protection of the law, as I've indicated. Medicaid is paid by the United States. It pays the majority of Medicaid funding, so it's like 57% of the funding. So you start to see how important it is to women and families who are concerned about getting decent advice to plan a family and abortions when and as they decide that that's what they want to have. Citing authority at page 31 of her opinion, the judge said the attainder clause is, quote, not the given and narrow historical reading, some give it, but instead must be read in light of the evil the framers had sought to bar, which is legislative punishment of any form or severity of specifically designated persons or groups. I am looking down because I want to get the language correct. I made some notes about it. And I thought, if I'm going to criticize the Washington Post editorial page, I should be careful what I say as well. They may not read it, they might not follow it. It's a political statement, in my opinion, which says something wrong about the entire operation over there. Now, the Congress set the criteria in this case in such a fashion that it targeted Planned Parenthood. And how did it do this? the punishment at issue is not just retribution for past ends, but it's also an effort to deter future alleged misconduct. And what they did, the way they targeted it, is categories of funding, and the description of the category of funding only applies to Planned Parenthood and two smaller other units. So they wrote it so that by describing the amount of money involved, they identified Planned Parenthood without saying, "Oh, we're getting Planned Parenthood here." Now, what is the net of it? The net of it is that we have an editorial board that goes and blasts a judge for respecting the Constitution, invoking those provisions consistent with Marbury against Madison, which set this power in the courts, so that there actually would be a check and balance between the judiciary and the legislative and the executive. And in this case, it has the specific power to look at this legislative act and decide, is this fair or not? And so the retribution for what Planned Parenthood has said, for what they could expect in the future, and the effort to deter further alleged misconduct, those are the reasons why the judge acted as she did. And there's probably not a woman in this nation that needs anyone telling her why this is wrong to cut the Medicaid funding. Jeff Bezos, who has a few coins in his pocket, said something important after Roe v. Wade was overruled wrongly. And what he did was he said that women who had to travel elsewhere out of their state where they live, work, to get an abortion, he would pay for that expense. Some have said they want him to do more, but you can't fault them on taking that position, and he's not the only one who did. But here's the thing. The editorial board on which he sits is doing this. They're attacking a positive step forward, legitimately in reliance on congressional provisions, and they uphold the right of a woman. Well, let me put it this way. They provide the resources for a woman to exercise the right that she had under Roe v. Wade, and she continues to have with some limitations that, in my opinion, have always been unconstitutional. So let me refer to here's the outcome. If you're a woman and can't afford an abortion, if this bill is not knocked down as per the judge's ruling, you're not getting an abortion. An unwanted child will be born. A woman may be put at sufferance. Family may be broken. All sorts of consequences flow from that. If you're a wealthy person and you want an abortion, you've got it. There's something wrong with that equation. You can't talk about equality in America and draw the line so obviously between the capitalistic wealth and the working man and woman of a middle income or less origin. So anyhow, I hope that made sense to you. What the Washington editorial did, the Post editorial did, made no sense to me, except to say it was a political broadside against women and against them receiving the proper medical care they need. And if this is where this nation is going, lip service for children, lip service for women, but hey, don't pass any legislation that actually would affect them positively. All the best. Talk to you soon. Bye-bye.